Hello and welcome to the beautiful city of Groningen in the Netherlands. People who are born here have great privileges. They got to be born in a rich and, even more importantly, safe country. People from Ukraine do not have this privilege. After Vladimir Putin invaded Ukraine in 2022, Ukrainians have to live in fear for their lives every day. The Western community had a consensus. We need to help Ukraine, and the most effective way to do so is by delivering weapons. But weapons kill. And this automatically poses the question, is it even legal? And this will be our research question today. And more exactly, we wanted to know to which extent are weapon transfers to Ukraine backed by international law? And we will not just answer this question. We will also talk about methodology, about how we answer the question and which type of question it is. Because we're university students. We don't just claim stupid things. We claim stupid things and justify it.
When transferring weapons to Ukraine, the West will need to do so on a legal basis, navigating the complex international law governing weapon transfers. It must be noted that the unlawful basis that Russia has used to invade Ukraine does not entitle Western states to provide Ukraine with weapons. So weapon transfers implicates three areas of international law: the jus ad bellum, the law of neutrality, and international humanitarian law. These legal concepts are independent from each other, and a violation of any of these concepts will mean that such weapon transfers are done so on an unlawful basis. So does the international order permit providing weapons to Ukraine, and if not, what might the consequences be? So the second independent legal concept, which could implicate the Western nations providing arms to Ukraine, is the law of neutrality, which is found in two documents adopted at the Second Hague Peace Conference in 1907. The law of neutrality is also part of customary international law, so it implicates all and every state. Essentially, the fundamental principle of the law of neutrality is that a neutral state is prohibited from providing any kind of support to a belligerent, that it is capable of influencing the outcome for the armed conflict, which is referred to in Article 9 of the Hague Convention 5, providing that every measure of restriction or prohibition taken by a neutral power in regard to the matters referred in Article 7 and 8 must be impartially applied when applied to both belligerents. But there's no indication that Western states intend to commit its own armed forces to the conflict in Ukraine, which would violate the duty of impartiality. But the prohibition of support is not a clear source of engaging in hostilities. Intelligence advice by the West to target Russian armed forces does violate the duty of impartiality, and yet the US seems to be doing so in a softer manner, with sharing information that helps Ukraine inform and develop their military response to Russia's invasion. But again, it's not on a legal basis. Reports do show that the US has provided Ukraine with real-time intelligence, allowing Ukraine armed forces to shoot down Russian air forces. Again, not done on a lawful basis. Providing military adversaries to such nations violates the law, and yet a number of Western states continue to do so. These states, however, they withdrew the advisors when the invasion became imminent. But if advisors are working with Ukraine, now they're doing so with no basis in international law. Article 6 of the Hague Convention explicitly states that it provides that the supply in any manner, directly or indirectly, by a neutral power to a belligerent power of warships, ammunition, any war material is forbidden. And at a minimum, the prohibition of support applies to weapons material, which is capable of being used for killing enemy soldiers or destroying enemy goods. And beyond that, the scope of prohibition is uncertain. According to legal scholar Castron, it would seem that it suffices for a state to refrain from delivering to belligerent material which is exclusively, or at least mainly, a military purpose. A number of scholars, however, extended the prohibition even further, most notably to include providing a state's military with massive financial assistance, which the West has done countless times during the war. Even interpreted broadly, the duty of impartiality does not prohibit all kinds of assistance to a belligerent. States are under no obligation to prevent their nationals from deciding to fight on behalf of one of the belligerents. A common issue is that states face is whether they can allow private companies to enter an internationally armed conflict, and states are under no obligation to prevent their national corporations from deciding to fight on behalf of a party. In conclusion, according to the current state of customary international law, the accepted view is that a state's permission to supply war material constitutes a non-neutral service, in which case the Western states are clearly violating its international duty of impartiality. So the remedy available to such a state can take proportionate countermeasures against the state until it ceases its non-neutral stance. However, the USA has endorsed an idea called the qualified neutrality, which applies when the Security Council has deemed one party to be one party of the conflict to be the aggressor. However, the SC or the Security Council has not deemed Russia to be the aggressor in its conflict with Ukraine. But again, this is because Russia has vetoed the resolution, and there is a general consensus among the 141 states that have nevertheless condemned Russia as the aggressor. So the Western states do qualify under qualified neutrality, but they are violating the actual law of neutrality, which again is independent of the jus ad bellum. Now we can look at how and if Western states are violating international humanitarian law. So there are three questions that we need to answer. Do states providing weapons to Ukraine become co-belligerents in the international armed conflict between Ukraine and Russia? So a co-belligerent refers to a situation in which states are involved in a IAC, which is international armed conflict, and fight alongside each other against a common enemy. So it is a party to the conflict, and therefore the IHL rules will apply to it. And the question is whether Western states become a co-belligerent when providing weapons. And the U.S. Department of Defense pointed out that whether a state becomes a co-belligerent is determined by the actions it takes in the armed conflict, not by the law of neutrality. So no Western state has actually directly participated in hostilities against Russia. A state could become a co-belligerent if it provides Kiev with intelligence, which the USA has done. But Grignon, a legal scholar, argues that any indirect military engagement that consists of taking part in the planning and supervision of military operations of another state suffices to establish co-belligerency. So the US has crossed that line. So there are a few scholars that insist that the systematic or substantial supply of materials of war to a state engaged in ISA makes the supplying state co-belligerent, but again, that is a minority position. So most scholars believe that supplying arms without more does not have a direct operational connection to qualify as co-belligerency. So it's very unlikely, in short, that foreign states can be considered as co-belligerents to Ukraine. Now, the second question that we need to answer is whether, regardless of co-belligerency, Russia can lawfully target the weapons that Western states are providing. And Russia's foreign minister has made clear that they will, any cargo that enters the territory, they will attack if it's considered to be helpful in the war against Ukraine. So, of course, the international humanitarian law permits this, and there is, but it must qualify as a military objective. And even if no Western state currently qualifies for co-belligerency, Russia is entitled to target the weapons that Western states provide to Ukraine. So, again, there must be a purpose, and that purpose must be if the use of that object has to be for the use of the object can be done for war. An attack outside of Ukraine by Russia might be lawful under IHL. The question is whether Russia had a reasonable belief that the attack weapons were intended against its forces. So again, there must be reasonableness and why you attack it, and that you must attack only war materials, and it must be shown that it's intended to be used against your forces. The third question under the international humanitarian law is whether the duty to respect and ensure international humanitarian law prohibits weapon transfer. So under Article 1 of the Geneva Conventions, there is a negative obligation which on states to avoid encouraging, aiding, or assisting a specific violation, but there also is a positive obligation on states to bring an erring party to a conflict back to an attitude of respect for the conventions, which basically means if the belligerent state that Western nations are supplying are committing war crimes, then they will not be able to do so on a lawful basis. So, Common Article 1's positive obligation would complicate the Western weapon transfers if evidence emerges that Ukraine is committing war crimes with weapons provided by the West, which is the key point, or that it has committed more war crimes than previously known. And if so, Ukraine's record would likely suggest the kind of foreseeable risk of future war crimes, and therefore Western weapon transfers would not be under a lawful basis. The decision by the Western states to provide weapons to Ukraine potentially implicates all three legal regimes, and they are, of course, independent from each other. The least problematic regime is the jus ad bellum. And in terms of international humanitarian law, states other than the US have yet to support Ukraine in a manner that could even arguably qualify them as co-belligerents. So therefore, there's no real implication under international humanitarian law. However, the law of neutrality has legal implications for supplying states. And because these obligations are not optional, Western states that are providing weapons to Ukraine are violating their duty of impartiality. And of course, it seems unlikely that Russia would actually take countermeasures, even though the West is clearly implicated by the law of neutrality, as there was no proportionate and necessary force to do so, and countermeasures cannot involve the use of force. And it is not clear, given Russia's increasing economic and political isolation, what kinds of legal obligations Russia could suspend to persuade foreign states to stop transferring weapons to Ukraine. And so in practice, any Russian response to weapon transfers beyond the targeting of the weapons themselves would likely involve the use of force and would thus be unlawful. Therefore, in a conclusion, my findings had found that essentially that the West is not really implicated in a real world sense by any international law when providing weapons to Ukraine, and if so, there is no real countermeasure that Russia can take that is proportionate and necessary.
So we have established that the transfer of weapons in the Ukraine has been to a high extent backed up by international law. In order to prove this, we must focus on the methodologies we have used in order to prove this statement. So first of all, together with Rishi and our sources, we have been able to evaluate to what extent the transfer of weapons in the Ukraine has actually been backed up by international law. Then if we focus on how our research question is structured, it clearly proves that we have analyzed legislation and expert order in order to show that the transfers were legal under international law. This means that there is an evaluating research question. We also used doctrinal research as we discussed the laws and customs already in practice. Because we did not focus on how to change the laws to help Ukrainian war, this means that it is not considered a normative legal research, but instead we have focused on trying to apply existing conventions in practice to prove and explain whether the actions of Western leaders are justified and legal. Last but not least, it must be acknowledged that the question of transferring weapons is by itself a interdisciplinary one, as both politics and laws are automatically involved. However, we tried not to judge politically, but instead provide a lawful standpoint to answer our research question. We hope that we have provided everyone watching the vlog a defense weapon, also known as juridical methods and facts, in order to defend yourself from populism and fake news. Thank you very much for watching, and have a good evening.